Fast forward, in Nkomo Chani, so I have AG Politics Avenue. On your podcast, the training book is making headlines. And a Jim Rennie be Exomo Ewa, and Edim Yahoo Braximus, and Edi can have special bit must subscribe to the channel. Hit notification bell so share. Now, a for so answer interim Kabi, and Edim Yahoo Braximu, Unia, Yanko, a political highways in Muna, a Jadema, and Yaksam to Accra. Now, a year Torkornoo remover Chief Justice, Getri Torkornoo. The application what they call a year Abuja Ecowas court and Ecowas to me Akasa in the press conference. Now in Sema Umu Eke Yunani said, since an application now what they buy Umu at dismiss a year application now Unia a year Arabo Semke Ede Emma a year get Torkornoo. Best say Yambo Ingra in Siminu. Shana Sumam say Haxi a GH politics avenue. Ajako Ajabo right now the path has been cleared for hair removal process.
Now, the Economic Community of West Africa Court of Justice, Ecowas Court, sitting in Abuja, Nigeria, has dismissed the preliminary objections filed by the Republic of Ghana challenging its jurisdiction to hear and determine the legality of the suspension of the Chief Justice, former Chief Justice Gertrude Arabaisaba Torkornoo. Now, in a ruling delivered today, the judges of the court unanimously held that the case is admissible and that the court has jurisdictional competence to hear it. Ghana, through the Deputy Attorney General, Dr. Justice Sremsai, had argued that the substantive application is manifestly inadmissible and that the court is manifestly incompetent to assume jurisdiction over the substantive application. And lastly, that the substantive application does not disclose any chance of success. However, the court dismissed the application the motion by the Ghanaian attorneys and also dismissed the application by the Chief Justice for provisional measures on the ground that the suspension had taken place over 3 months before she approached the court for legal redress. Ghana was subsequently given 30 days within which to file its defense to the substantive case.
While the applicant met the 5-year timeline for applying for review, but their failure to satisfy the requirements of the new facts renders the compliance invaluable, as the requirement of admissibility of an application for review are cumulative. The absence of one of them is sufficient to endanger the admissibility of the application. In the light of the foregoing, the court hereby declares that the application for revision of judgment number ECW/CCJ/JUD/44/23 delivered on the 24th of November 2023 is inadmissible. And for that reason, sitting in public, the court declares that it has jurisdiction to determine this case. However, declares the application is inadmissible and orders each party to bear the cost. The full complement of this judgment will be made available to parties upon signature by panel members.
Thank you. Yes, counsel.
Me for the applicant?
Yeah, the applicant.
You know, we want to say to the court, in as much as some, view that the matter. The only contentious issue we had to raise this court was the issue of the court said that the simply repeat.
And that's the former CJ's attorneys as they were addressing the court. Let's try and bring you a bit more from this with respect. The Deputy Attorney General, who was representing the state, has been writing on the back of that hearing today. Let's take you to our big screens right now and get an understanding as to what it is that he's been saying in the aftermath of that particular ruling. And then we'll subject this to a bit more in terms of scrutiny and possibly take you to the legislature as well for quick reactions as to what's been happening, because we know the minority had been making a strong point that, look, there were matters pending before the court, and one of such reasons why they did not partake in the vetting of the Chief Justice Paul Bafuboni. But here's what the Deputy Attorney General has been saying, that the Ecowas court has this morning dismissed Mrs. Justice Gertrude Torkornoo's application for interim measures. The court stated that the application did not satisfy the criteria for a grant of interim measures. More particularly, the court held that the applicant's own conduct defeats her claim of imminent and irreparable harm. The court is therefore satisfied that the applicant has not demonstrated the existence of eminent or exceptional circumstance that would justify the urgency of the application filed almost 3 months after the act complained of. In the light of the applicant's failure to meet the requirement of urgency, the court finds no basis to assess the remaining criteria for provisional measures, same being cumulative. The request for provisional measures, as outlined by the applicant, same not substantiated, is therefore dismissed. And so these interim measures, if we could break it down, the former Chief Justice was praying the ECOWAS court to, in the immediacy, deliver judgment on her behalf, so she's declared a victor. And the court said, well, they could not do that because the irreparable harm that she saw is arguing as a basis. Well, she came to the courts after a while, 3 months after the action, which was her suspension and the subsequent work of the committee started. She came to the court 3 months afterwards. And so there was no immediate urgency and a basis upon which they will grant her that demand. Also, the Attorney General, that's the deputy, they raised the subject matter of whether or not the court had jurisdiction to hear the matter brought before them by Madame Torkornoo. Essentially, an argument the Attorney General seems to make in almost every suit they are a part of. They challenge the jurisdiction of the court to hear the matter, and the courts dismiss same. And so that's what happened today. 2 applications, motions, call it what, dismiss, one for Madame Torkornoo, the other for the Attorney General, who were challenging the jurisdiction of the court to hear the matter as brought before them by Madame Torkornoo. And subsequently, the Attorney General has been given 30 days upon which he can file his defense, and then they'll return to the court for a substantive date upon which the matter will be heard, and then there will be the delivery of a verdict on the case as brought by Madame Torkornoo. Let's bring back a recent interview my colleague Joseph Akable had with the Deputy Attorney General, Justice Tremsai, who challenged the jurisdiction of the ECOWAS court to hear this particular matter, which has now been ruled on.
Dawn, we woke up to another process which was served on us from the court, that the former Chief Justice is seeking judgment in default of defense. In other words, that we've not defended the substantive suit. We had 30 days to do so, and that we have not filed our defense. But our preliminary thought is that if we are objecting to the jurisdiction of the court, and the court has taken argument and has adjourned to give a ruling one way or the other, we do not exactly think that we have to file on the substantive issue, because the question before the court is whether the court has jurisdiction. The court has to clear that aspect first, and when it says that it has jurisdiction to assume, then they will order us to file our defense. And indeed, if the court was interested in getting the court could have ordered that we should file our defense together with our preliminary objection, because we were heard. It's not as if we argued that matter in court, in the ECOWAS court, and we were heard. And the court in adjourning didn't give any further direction. They told us that they are rising, and then they have adjourned the case, indefinitely. And when they come back, they will give us further directions. So we were waiting for the court to give us further direction, only to be served with a notice for default of defense. So that is where we are at the moment.
So what are the next steps? You'll be applying for that to be thrown out as well?
Yeah, we would have to file to oppose the application for default judgment.
And And that's Justice Tremsai, as a Deputy Attorney General, doctor as well, speaking to my colleague Joseph Akable some time ago on the subject matter of jurisdiction. Well, the court says it has jurisdiction. Let's take you to Parliament right now, where my colleague Christian Yale is hoping to get a bit of reactions from some members of Parliament on this latest we're hearing from Ecowas. Christian, talk to us. Has there been any reaction, particularly from the minority who sought to boycott the vetting of the Chief Justice, Paul Bafuboni, on the back of one of such cases, one being heard today?
Eric, so as of now, I can tell you that I have made some contact to the minority side, especially those who speak on constitutional and legal matters. And as of yet, because it is also a fresh decision that has been taken by the court, they would want to tarry a bit in making some, reactions to it. But just a while ago, even I engaged about two of the MPs on the minority side who are equally lawyers who understand the issues and how they are, and they've all indicated that as of now they wouldn't want to comment yet on the issue. But and just as you had indicated, it is one of the issues that the minority members have been referring to before the vetting of the Chief Justice, the new Chief Justice. They had sent a motion to the Speaker's office demanding that the vetting of Paul Bafuboni be halted until one of those 7 active cases, which one happens to be what the Ecowas court has decided on today, has been dealt with and determined. Again, even during the vetting itself, it was one of the issues that the minority leader had sought to raise, that since that case is also there, we should wait for the determination. Right after the vetting, yet again on the floor, he had again sought to make his case on that same front. And so when you look at all the 7 cases that Torkornoo has filed at the respective court, the Ecowas court, the High Court, and that at the Supreme Court as well.
Thank you very much, Christian. We'll have to connect with you a lot later on what is expected in Parliament. But let's speak to former Attorney General and Minister of Justice, Akuffo. He is also the lead counsel for Torkornoo. Counsel, I appreciate you joining us. Your immediate reaction to this ruling by the ECOWAS court, you were seeking some interim judgment in your favor, but the court says there was a lack of urgency because of the many things that you should have done, you came to the court late.
Well, thank you, but the point is that for me, this is not newsworthy at all. You should not be wasting your time reporting this matter. What should be reporting is the preliminary confession that the government through the Attorney General went to take.
I'm actually going to come to that, but I was just finishing on the subject matter of the court stressing that.
You let me learn. I have started from somewhere. When I learn, you understand. You see, when the matter went there, what they said was that the court has no jurisdiction to hear the matter because there are cases pending in Ghana. You remember?
Yes.
And then we said no. For the Ecowas court, so long as there is an issue of breach of fundamental human rights, you can come there whether a case is pending elsewhere or not. So that's what we said. Now, we have succeeded. Now, I'm going back to give you the background. I know where you belong and the kind of things we people talk there. But I'm telling you that, look, the background is that this is not newsworthy. When the woman went to Ecowas court and also went to the High Court in Accra and went to the Supreme Court, he told everybody that while this case is pending, please hold your horses. Let us see the ruling. They said they will not have any of them. They went and presented a report. They went and nominated a new person. They took the person to Parliament. Even the minority said, no, what you are doing is wrong. There are cases pending. Let's hold on. They said they will not hear anything. Then they went ahead and now sworn in a new Chief Justice. What do you think they have done to the Ecowas court? They have fixed them with a fair complaint. That we are finished and we now have a new Chief Justice. So what is the point of giving any interim measure at this stage? It's better to hear the case. So what the Ecowas court is saying is that, look, as far as these interim matters are concerned, we are no longer interested. We are no longer interested. We want to hear the matter. So you have not filed your response yet. We are giving you 30 days.
All right.
Go and file your response so that we go into the matter, whether or not fundamental human rights have been breached. That is where we are. So this one, it is not newsworthy for you to be talking about it, because we all know that there is a new chief that's doing this morning. So what are you talking about? What is it? What is it that we are happily and beautifully, talking? What? It's not of any newsworthy. As far as I'm concerned, it is not newsworthy.
Right.
They have fixed them with fear complete, and they are finished, and that's all. The Ecowas court said, well, if this is the matter, let's forget about it and go into the matter itself, the substantive issue. That's all.
And that substantive issue, I hear you on the fact that this is not newsworthy, but we have insisted on reporting everything as has happened, including mentioning that the Attorney General's argument about a lack of jurisdiction of the court was indeed dismissed, and we've run viewers through that. But on the subject matter of the fact that you make the arguments that a new Chief Justice has been brought on board amongst many other things, and the court says they are not interested in those interim matters, where does it leave your substantive case?
Oh, the substantive case is a different matter altogether. In the sense that, look, when a case is pending and you go and ask for an interim injunction, like the authority will not grant, it doesn't mean that at the end of the day, he will still not give you judgment. For example, you have to weigh what we call the hardship on the parties. The necessity and all that. How relevant will granting the application be? And all lot of factors will be taken into consideration. It doesn't mean that they are going into the substantive matter. But the law is, they don't have to touch the substantive matter at all when they are dealing with interim matters. So as far as we are concerned, they have rather made a point quite clearly that the former Chief Justice has demonstrated demonstrably that rights have been violated, for which reason they want to get into the bottom of the matter. That is the issue now.
If we move away from the Ecowas court and return to Ghana as well, similar such applications are pending before the court. You've mentioned the minority raising concerns about why these pending cases should not have resulted in the appointment and subsequent approval of Parliament and the swearing in of a new CJ. Are you and the former Chief Justice concerned about what some say is a delay in hearing these substantive matters pending before the courts back here in Ghana?
You heard Afenyo making all those points. Even as at the time, just like they did in the Ecowas court, they refused to file their responses. And then just when they were about to bring the new Chief Justice nominee to Parliament, then the Attorney General goes to ask for 3 weeks adjournment, within which extension of time within which he will file a response. You heard Afenyo saying so. The chairman said he will not have to hear anything about that. Anything which has to do with the judge or the court, they are not there, so he will not listen. The chairman was presiding. So it is not that these issues have not been raised. We have raised it several times as lawyers. That's all your fire. Even if you remember, we did not conclude the hearings at the Bawumia committee because they have adjourned the case to a date when they will hear other complaints. The date did not arrive, and they went quickly and presented the report. We said all these things already. So that's why I'm saying that this is not newsworthy. I don't know what they are fully, shouting over. What have they done? In fact, there is evidence I can show to you that the lawyer in Nigeria, Falana, wrote to the committee that the way they were going about this matter, that is the court, and all the matters happening, we are no longer interested in the interim application. The letter is there asking whether he was not safe. Ask the Attorney General whether he hasn't got a copy. So we have already taken that decision. Now look, it's complete waste of everybody's time. Letter was written of them. You've been doing all sorts of things against this hearing. Let's go and hear the matter.
Right, But you will agree with me that on matters of jurisdiction, and you've been Attorney General before as well, it is something that always comes up when there's a case involving the Attorney General. You, more often than not, want to question whether or not the forum upon which the court is being asked to listen to and determine a matter, the court does not have a jurisdiction.
What point do you want to prove? Because we are telling you.
I'm just making.
You must have a basis. You must have a basis for doing so. In all those other cases, you don't go to the international forum until you have exhausted the internal procedures.
Right.
But for the Ecowas court, it is different. If you are talking about a breach of the fundamental human rights, so that court has jurisdiction. We told them, they didn't listen. And they went and raised that then to waste everybody's time from the time the thing was filed up to today. They are now giving 1 month to go and file it. So it was baseless. The objection that they decided to take was complete, but had no legal basis.
Right.
They just went there to waste everybody's time.
Counsel, I appreciate you speaking to us always. Thank you very much. That's former Attorney General, the Honorable Akuffo, to speaking to us on the aftermath. He says that, look, that dismissal on their part, they had written already stating that they were no longer interested in it. And so the subsequent application by the Attorney General seeking to challenge the jurisdiction of the court has been a complete waste of everybody's time. Let's take you back to Parliament, because I mentioned we'll return to Christian, or to pick a bit more in terms of reaction to this. Christian is with a member of the Constitutional, Legal and Parliamentary Affairs Committee of the Legislature. Christian, talk to us. What is the House saying in reaction to what has played out this morning?
We are yet to hear from the minority, but Eric, you do understand that over the period, it is one of the cases that they have cited in protesting the appointment and vetting of the new Chief Justice, Paul Bafuboni. In fact, the motion that they had sent to the Speaker demanding a halt in all the processes leading to the vetting of the Chief Justice cited the Ecowas case, which has been determined today. Again, even during the vetting itself, the minority leader had sought to make that case as well. And even after the vetting and during the approval process in Parliament. And so we wait to see really what would be their immediate response or their reaction to this ruling. But I have with me a member of the Constitutional and Legal Affairs Committee who is himself a lawyer as well, and I have had an earlier engagement with him before concerning this issue. Lawyer Fifi Bachman is the MP for Kwesi and a member of the Constitutional and Legal Affairs Committee. What are your preliminary thoughts on the ECOWAS court's dismissal of Torkornoo's case?
Oh, it was anticipated. Some of us have stood on that, and I've always said that, looking at the circumstances of the case, I mean, going to the ECOWAS court, yes, you have the right to go to court, and sometimes I even make, mockery of it, that you can even go to The Hague because you have the right to do that. But that shouldn't be a stance on which you would say that her right has been trampled upon, etc., which goes fundamentally to affect her. And so everything should stand still, especially when we were vetting and approving the new Chief Justice. So it was anticipated, and I think that the ruling of the ECOWAS court is succinct and it sits with law and procedure, because for procedure, you are saying that you have an issue within your country. You have the right to go to the ECOWAS court. You have the right to go there to seek an interim, order or an application for an interim order. In that stance, or in that particular case, you'd have to prove something. You have to show that there is a special circumstance warranting they granting that application for you. But what they have said, if there is a special circumstance, then it should be within some time. We should show that there is a substantial miscarriage of justice, and that miscarriage of justice is affecting you, ASAP.
But the court also dismissed the preliminary objections by the Attorney General that it did not have the jurisdiction to sit on the case, and also establishes a prima facie of some violation of human rights against Torkornoo. How would you respond to that briefly?
No, for that one, if you are saying that there are some fundamental rights, human rights breaches, we would have to get to know about it very well. Is it that there was some procedural impropriety? Is it that because everything boils down to human rights? So if the fundamental human right has been, violated, then we have to come back, look at it from the courts. But I think that all in all, the courts have shown fairness. The courts have decided that yes, they have the right to hear, because if they otherwise their appellate jurisdiction, that jurisdiction that they have, that if anything happens to somebody in a particular country forming membership, that person cannot go there. So they accept it, but they dealt with the substantive matter, which is very important and very a landmark, decision.
Thank you, Christian. Christian Yada is my colleague in Parliament, there for us, helping us get an understanding in terms of a reaction from some members of Parliament. But we will switch now and bring you some other stories this afternoon here on News Central.
Now, the Minister of Roads and Highways, Kwame Gavin-Sagboja, says moving forward, there will be a clampdown on overload.
We and Semahood were Timiko channel, so I'm not so Jimmy or had a senator body in the Adumia, Unia, Yansan Sumo, not Yanfadi Chinsi and San Embro.